thank you everyone for showing up today and hearing how we could make a better impact in our communities, our employment journeys, and just our journeys as individuals in a larger community. So today I am Stephanie McLean. Well, I'm always Stephanie McLean every day. She's like, oh, does she change? No, I'm Stephanie McLean. I am a licensed electrician here in Ontario, Canada. I've been in the trade since 2014, so I'm coming into my 11th year in the trade. And I worked with TCBN, Toronto Community Benefits, as a mentor. I sit on their Her Path Forward committee here, and my focus is diversity and inclusion. So we as a team worked together for several months putting this wonderful presentation, this event today, to help educate everyone how to become better individuals in their paths of employment, especially in the construction industry, and especially focused on women, because we are already the minority group, and teaching ourselves and our allies how we should be represented and how we can be heard through our different channels, especially in the ministry, I think is one of the best steps forward to change. So welcome, Carey and Shay. So we'll jump right in to our panel. So we're calling this Building Inclusion from the Inside Out. And our first question that we have here, and it can be directed to either one of you, whoever wants to answer, is to help set the stage, can you briefly explain the overarching mandate of the Ministry of Labor, Immigration, Training, and Skills Development, and how it supports fair, safe, and inclusive workplaces across Ontario?
So as we mentioned, the Ministry of Labor, Immigration, Training, Skills Development, it falls under, it's always a mouthful. I'll just work with Ministry of Labor.
Yes.
It falls under the government of Ontario. And like I said, the main focus of the Ministry of Labor is really about, fair, safe, and healthy workplaces. That's the key, and that's why Fishwood is the largest division in the ministry. We have probably thousands of employees. So we are just trying to ensure that, the legislations are enforced, employers especially are complying with the legislation, whether it's the OSHA, which is the Occupational Health and Safety Act, or the ESA, Employment Standards Act. So we just try to make sure that those are enforced. And just to sidetrack a little bit, they're actually hiring new officers in occupational health and safety. So on the construction, they're adding like 32 new officers. Industrial, I believe that's 54. So again, we're adding additional officers just to make sure that there's compliance within OSHA, and the ESA will also be doing, hiring under the Employment Standards Program as well. So again, it's just to ensure that people are treated fairly.
Right.
They have a voice, employees have a voice, and a lot of times we act as that voice because, again, everybody wants to get paid. You're going to work to get paid. It's unfair for you to go into a workplace, you work 40 hours, and the employer decides, I'm going to pay you 20.
Right.
What about the other 20? So then we're there to ensure that.
Right, and also I would think, to make sure that employees get home safe to their families. Number one thing.
That's, and again, that's why we're doing that employment drive, again, is that we can have more officers, more inspectors on the ground in the occupational health and safety field. And again, it's across all aspects. So it's construction, it's industrial, it's healthcare. So we're spreading that out just to make sure that there can be more inspections, so again, people can get home safely.
Right, so thank you for even mentioning that they're hiring. There's openings for hire, because you know what? I really thrive on that point, because We want to be the change we want to see. So if we want change, we need to make sure we can get into these positions and have our voices heard and have that change being recognized and acknowledged. So thank you, Carey, for that. Shay, would you like to add anything?
They're also hiring for employment standards officers as well.
Okay.
So just putting that out there.
Employment standards
Yeah.
officers, we
If
need
you're
that.
if you're passionate about helping other people receive their pay and their minimum standards, maybe you should put an application in.
Thank you. Thank you very much. All right, so we'll move on to our next question. So, if an issue arises on a job site and an employer fails to take action, what formal steps can workers expect the ministry to take to ensure accountability and resolution? And I know you've touched upon this in your PowerPoint presentation, but let's just reiterate that again.
Yeah, so there is the 1-800 number that you can always call. You could give the information. A lot of times they'll try to understand what happened. They'll also try to give you education as well on your rights. And then, they'll try to, resolve it. Again, that's just the first step, the minimum. And then from there, they will also encourage you to file a claim if they believe that, yes, you have been wronged or there's something that the ministry needs to look into. And it will take different ways. So, for example, if it's on the OSHA, it can be where, we have to dispatch somebody immediately. And so that's why there's always that 1-800 number that somebody's always at, whether it's after hours. There's always somebody there. There's always a manager on duty. There's always an officer on duty. So, there's always somebody there to respond. I think recently there was this incident with, there was an accident, was it in Oxbridge? And 2 firefighters were hit at the accident scene. They had to call the Ministry of Labor because firefighters are employees too. Right. So we had to get involved in that. So even though they're government workers and all of that, we still have to get involved to do the investigation and all of that. So there's different processes that it could take. But if it's filing a claim, again, once you file that claim under OSHA, inspector will come out. Mm-hmm. And as mentioned, as Lisa mentioned earlier, it's you can remain anonymous, but in some sense. So if there has to be an investigation that that's going to take place, there's sometimes where information has to be disclosed to the employer, and we'll try as much as possible. If you want to remain, we'll try as much as possible to do that investigation. But there are times when, and we'll let you know, there's times when we have to disclose certain information just because we want to do a proper investigation for you. So then, and then again, sometimes when we bring things, the employer might figure who we're talking about. So we try to, keep it confidential if you want to, and we'll try that. But again, we can't guarantee because, again, the employer might figure, and I'm not trying to say this to say, oh, don't file a claim. You have rights. You should always file a claim. I can tell you that. And again, an employer cannot reprise against you. They can, of course, but that's where we have a lot of teeth when it comes to reprisal, because we determine how much we award when it comes to reprisals. So we have heads of damages, different heads of damages that we go through. And as Shay mentioned, it's specific to, okay, how many weeks did it take you to find a job? 20 weeks? Okay, we can audit 20 weeks of wages. If it takes longer, we can. We have that leeway. Pain and suffering, if you say, you went through financial distress, we can say, okay, you know what, $2,000 for your pain and suffering. Did you incur expenses trying to find a new job? You had to print resumes, you had to do this. Okay, we can award that. So we have a lot of teeth when it comes to reprisal. We have a lot of leeway when it comes to reprisals. So again, that's why I could tell you, you have rights, you should establish your right, and you cannot be punished for that. I mean, they can, but then that's where we come in. You had a question, Lisa?
So one of the things that is really great about Ministry of Labor and all that certain things have come about with things being reported to the industry, some changes that have been made within the industry. So when I first started was with the stage collapse. I don't know if anybody heard about the big stage collapse that happened around Christmas time. So because of that investigation that occurred or whatever, that then in turn put in place the working at heights requirement with Carey, right? And so where everybody has to do the working at heights, and you have to have that level of certification. So that's what happened because of that level of reporting. The other thing was the down to stage collapse that happened. And again, that went through my office as well. So with the down to stage collapse, then that, again, then heightened, I think it was Live Nation or whatever the case may be. And 2 people died in regards to that. It got as far as with England. That's when the person that died actually was from England or whatever. But that also helped then with all the blitzes that they do as well. So with the occupational health and safety program, there's a lot of the blitzes that are coming out in reference to that because of all this level of reporting, right? So where they can showcase and focus on certain types of events that are happening. So like they do the roofing blitzes, they do crane blitzes, and all that kind of stuff. So things that they can really focus on that they know are commonalities that are always recurring, the dump trucks being up and hitting the wires and stuff like that. So we do that kind of stuff. So that's why all this level of reporting and the importance of Ministry of Labor is that we can bring these things to light and then certain changes can happen and you can see that within the real places.
Right. Thank you, Lisa. And as we're sitting here and having conversation, it made me think about situations where you feel like you need to report the situation to the ministry, and the investigation's going on, and now as an employee, you're feeling uncomfortable at work, you're getting bullied and picked on because, you know, this investigation is going on, things have gotten out. What happens to that employee or for that employee in this situation based on ministry standards?
So that technically will be the reprisal that we spoke of. So at that point, you file the claim is in process, you're at work, the employer is like bullying you because of this. You report that, it gets added onto the claim, we throw the reprisal allegation in there. Right. The employer has to prove that they weren't bullying you, of which at that point, like if you have evidence, they can't really prove it. So that's when a reprisal allegation can take a small claim of the employer not providing you wage statements or something, right, to them paying you like $10,000, right? So it's like you shouldn't be scared of that. Like if anything happens, you report it immediately. It gets added onto your claim. The ESO that's working on your claim will reach out to the employer immediately. Mm-hmm. There's a reprisal allegation against you. Usually when we reach out, explain the reprisal, like that usually stops them in their tracks, because like now they're scared. They suddenly find out that they could be owing you thousands of dollars, mm-hmm, or have to pay you this much money, and now they're like, oh no, like that wasn't the story, we weren't bullying or anything. But they like it strikes fear in them most times.
Right,
yeah.
Right. Yeah. So would you suggest that the employee who feels that way stop going to work, or they should still continue to go to work?
I feel if you can't go into work, you could decide to leave the job, and that would be factored into the reprisal payment at the end. It's like I wouldn't, like, it's hard to say, depending on the situations on a case by case basis. If you're really uncomfortable, don't go into work. Like I wouldn't recommend you go into a job where you're getting bullied and harassed every day. Sure. You make your reports and let the ministry handle the rest of it.
And I could add to that as well. So under the ESA, there's also what is called constructive dismissal. So essentially, if you are being bullied and you're being harassed and you report it and it's continuing, you have a right to resign. You have a right to leave. And then you could file a claim for termination pay. And that would come under constructive dismissal. As long as you resign within a reasonable time of what's happening and you have like, you can say, look, this has been happening, I reported it, the employer just continues, you're not doing anything about it, I don't feel comfortable, this is a toxic environment. You can resign. And then they'll still owe you termination pay, because typically if you resign, you're not owed termination pay. But if it's something like that where you're being bullied, then that's constructive dismissal.
All right, cool. Thank you. Did you have a question? Perfect. Perfect. Because as a female in construction, I mean, I see a lot of the times the guys getting hard on the other guys. As soon as WSIB or anything is involved, that's when you start hearing, the chatter, the lunchroom talk. Guys are talking negatively about other guys or saying like, why did they have to do that? And then, it could circle around, and that type of energy and idea of an individual gets passed around, and I could see a situation kind of going south that way. So thank you for giving us the information about that. Did you want to add anything to that, or we're good there? Nice. Okay, perfect. So in your experience, any one of you, are there common timelines or procedural steps that workers or employers often overlook? And how can we better support workplaces in meeting these requirements to foster a more inclusive and compliant environment?
Okay, so the first one I'll start with is, if there's an incident at your workplace, I recommend filing immediately. You have 2 years from the date of the incident to file your claim, or we don't have power to investigate it. So recently I had a claim where the person was filing for vacation pay. It was from 2021. They filed it in 2024. I had to reach out to that person and be like, I don't have the authority to even investigate this. So it's usually, if there's anything going wrong, keep your evidence, file your claim immediately. That's usually the best advice I can give. Next, another thing is, so when we reach out to employers, we usually assign them like a timeline to provide your information, your documents, the records, anything on their end. We give them about 10 to 15 days. Most employers will like, oh, I'm busy, I'm out of the country, and they won't provide this. This just delays the investigation. So we don't let them like just pad the runtime and just hope the investigation will go away. If the employer isn't providing their evidence in about 15 days, I reach out, I follow up, I do my due diligence. I'll follow up and make a decision based off what the employee has provided me. Because then if your employer can't provide the records to back themselves up, it's already suspicious. You know what I mean? Yeah, so alongside the timelines for claims right now might be a little bit longer. If you were to file a claim right now, we're looking at a few months of turnaround time. If I get a claim assigned to me, we try to work on it as soon as possible, but delays with getting records, with doing the investigations, anything, even at times trying to reach the claimant could take you almost 2 weeks. So we try, but technically a turnaround by the time you get it assigned to an employment standards like to either of us, it could be anywhere from a week to maybe 9 weeks, around there, just to work on the entire process, get orders out and all of that. Yeah, and then payment orders. So this is another one. So when we tell the employer to pay you what you're owed, we give them a month to make the payment or appeal the decision. If they don't make the payment in a month, then we start going after the directors of the corporation. And eventually, if that doesn't work, we send it all to collections. So this could be another like longer process to receive your payment. And at times, even if they pay, it has to go to the Ministry of Finance, and it takes a couple of weeks as well to be processed for you to receive your payment. So if your employer does pay, as of right now, we're looking at around a 6 to 8 week timeline for your payment to be processed and get into your account. So there's multiple like different stages, different timelines in these processes that extend the claim process. But again, like I would say, the most important one, you just make sure you file within 2 years of the incident. And us in the ministry, we're trying our best. That's why we are employing new officers as well, to try to reduce the processing, the timeline for like the claims process. So if you file a claim, you should be able to get a response as soon as possible, and everything should be resolved almost immediately.
Nice. You wanted to add?
Yeah, just because you just mentioned the director aspects of things. So when it comes to employment standards, this is one of the few times that the director doesn't have that corporation veil protecting them. So most times, for example, if you heard that a company went bankrupt, the directors probably are okay, but under the ESA, there's certain things that we can hold a director liable for. So payment of wages, vacation pay, stuff like that, we can hold them liable. So if we issue an order to the company and the company don't pay and they didn't appeal, as you said, within the 30 days, then we start a director liability investigation. And then if we find that, okay, the director was the director at the time when the contravention happened, then we determine, okay, what aspects of these wages that we found owing is this director liable for? And then we issue an order against that director personally. So now he has a personal record to pay the wages that we found owing. So he can't stay behind this corporation and say, oh, it was the corporation that employed this person. I wasn't there. You're a director of the corporation. We can hold you liable for certain wages.
Great. So as I'm listening to both of you explain the timelines and the next steps, so I'm going to play a little bit of devil's advocate. Okay. So I'm a person, employee, who I want to make a claim, and I have all this emotion, and we should know, or at least if we don't know, emotions are energy in motion. So I'm fired up right now, and I need an answer, and I need a decision right now. So I put my claim in, but things are getting worse. I'm still fired up every day. Work is, turbulent. It's getting crazy. This timeline of, immediate response to at least 9 weeks, where do we fall in with this? Because I know most of the time when, employees want to put claims in, things are happening right now. So how does that play a factor in your roles?
All right. This is...
Is it common?
No, it's because the difficulty I have in answering this is because, to be honest, there's a backlog, a huge backlog of claims. And that's why when you put in a claim now, and unfortunately, it may take months before it gets to us. And now, an early resolution officer will contact you, within like maybe a few weeks of you filing the claim. And if it's not resolved early with that officer, then it gets escalated. So that's why we're kind of hiring new officers. We did a hiring blitz with us a few, this last year? Yeah, because we're like 1 year in. So we're trying to get that backlog cleared, because right now it's at about 9 months, to be honest with you. So no, unfortunately, no, I'm not familiar with the OSHA timelines. I think theirs are usually quicker, to be honest, because they're in the field. So they'll just take it to the field. So it is OSHA, because for example, workplace harassment, so, bullying and stuff like that, sexual harassment, that falls under OSHA and not the ESA. And that's, important to know. OSHA timeline definitely is a lot faster. So if it's bullying, workplace harassment, sexual harassment, that goes to OSHA, and their timeline is a lot faster than the ESA, I could tell you that much. Okay. Don't know their timeline specifically, but it definitely is faster, and their report is usually faster because they're gonna go right there in the field and do the investigation in the field.
If they get the call today, they go up.
Yeah, so they go in the field.
They also triage in terms of level of importance. So depending on if it's a fatality, and you get
it's immediate.
The call comes in, whoever receives the call, that inspector has to go immediately. Okay. Right? Some things are like dust control or something. That's something the inspector can call and then decide whether or not they want to go out. But depending on how severe it is as soon as the phone call comes from the contact center to the person that's now delivering the message to them, it is like right now, get in your truck and go.
Okay.
Yeah, so that's the OSHA timeline. So it's a lot faster. Okay. So most of the critical things, the safety aspect, the healthy workplace aspect, is OSHA, and they're a lot faster. The other aspect is, us, and we're trying to work on the backlog, but it's there. Okay. So it will take months for us to get your file and complete our full investigation.
Right, so this is on the employment standards.
Yes.
Right, just making that clear for everyone. Yeah. All right, wonderful. So those are the questions that I have. I'm going to open it to our audience and take some questions from the audience. Yes, I will walk over with the mic and make that available for everyone.
Hi, good afternoon. Good afternoon. I'm Tonya McLeod. I just have a question in regards to the officers. is there a difference between the health and safety officer and the MOL inspector that goes on the job site? And if there's a difference, what's the career path for those two inspectors?
All right, so the
Thank you.
as you mentioned, the MOL inspector that goes on a job site is the same OHS inspectors. So it's the same thing, occupational health and safety inspectors. And like I mentioned, there are different occupational health and safety inspectors. There's the construction inspectors where they just focus on construction sites, full stop. Then there's industrial that go into the different the factories and stuff like industrial work. There's healthcare that deals with hospitals, health, long-term care homes, stuff like that. So it's different. I can tell you, I don't have the full details of the requirement. I know most of the times they focus on, for example, if it's construction, they do focus on that construction experience a lot. So that actually is a big factor in the hiring process. They also try to look at people who can, understand the legislation, read and interpret the legislation. That's usually a good point or part to go. But definitely construction, because I know when it came up, again, I don't know all the details. I know like my manager did mention at one point that, they get a lot of application, but they don't see a lot of application with that construction experience. It's like, I wouldn't apply because, I walk into a site and I have no idea what I'm looking at. So how can I tell you that it's safe? Or, they provide training. And I can tell you from our experience, the training is months, and they bring you through everything in terms of the legislation, how to read it, how to interpret it, how to apply it. So the training is very extensive, but they do look for that construction background.
And for the ESA, the employment standards, like for us, they just pretty much similar, like if you can read the legislation, understand the legislation, explain it, that's essentially what they're asking for. Because for myself, I had done environmental assessments before, so I had dealt with the legislation, and that was like, that directly transferred to this job. But they provide months of training still. So if you look up the job ad, it shows you the requirements. It's not as crazy as you would expect, but it also says if you don't meet all the qualifications to still apply, like they'll give you a fair chance based on your resume. So it's so like I said, if you can find the job ad online, I said look up the requirements and try to match it to yours. Sorry, Lisa.
So for construction inspectors, I can only speak on construction inspectors or whatever. So those particular inspectors, right now I think they're looking for about 17, specifically in Thunder Bay, Toronto East, and Toronto West right now. In terms of requirements, it's really, yes, you have a construction background, but you have a level of enforcement, and you know how to read legislation as well as enforce legislation. And if you can demonstrate that in terms of your resume, cover letter, and all that kind of stuff. To their point or whatever, it is a very extensive type of training that the occupational health and safety construction inspectors receive, because you're going through all different types of legislation in terms of construction. So normally an inspector for construction will be, I think about 2 years. So the first year is like training. The second year is really like people holding your hand and driving you out and babysitting you a little bit. By the third year, or depending on the manager, because I've seen one inspector who was graduating and the same day there was in a critical. So in the middle of the graduation, he had to leave. He just got badged and he had to get sent out. So depending on the manager, whatever. So you could say like by year 3, you should be independent enough in order to do what you're going to do on your own. But then you should be relying on your team in order to support you as you're going through that journey right now. So there is an active posting right now, and I believe it's about 17 inspectors that they're looking for right now. And especially for Toronto, Toronto is fairly busy. It's one of the busiest regions. There's 2 separate regions. There's Toronto East and Toronto West. And then all the other regions are a little more, I wouldn't say quiet, but they don't deal with the Toronto core.
right?
And for like an inspector, like the candidates, the construction candidates that they probably consider, would these mainly be like journeymen, or it doesn't matter?
Anybody.
Okay.
Anybody. You don't need, I think the question came up over here was that do you need specific certifications and CRSPs and all that kind of stuff? I know for the inspectors I've worked for, it's just because they had a construction background, they were able to enforce the legislation, they understood the legislation, and all that kind of stuff. I mean, if you come with all these different certifications, it's great. Enhances your skill sets in order to be able to deal with what's in the field out there. But there's not a requirement there. And like you said, you know, they do encourage everybody to apply, and even if you don't feel like you have all the requirements or whatever, it's good to see, because you never know. You never know. You might be able to get inside there or whatever the case may be, do the interview, but if you don't pass the first time, at least you have an idea so that when the next time happens, because they're always hiring. Most people that come in, and I can speak for construction, once they come in and they see Toronto and they're like, oh my gosh, look at all these cranes. You know, and then they start moving out to different regions because it's a little more quieter or whatever the case may be. So they're constantly hiring, especially the Toronto West office, constantly hiring, and it's due to the parking. I know that. I know the parking at Yonge Street is a little to park those trucks, right? So Toronto East, which was my office, is on 2275 Midland Avenue. It's free parking, so it's great. So a lot of people like to go to that office. But yeah, anybody can apply.
My question was, what are some of the the complaints that you get that are really popular? And then also, what is something important for people to know when making a complaint that is often a mistake or missed?
Oh, we get tons of complaints for everything, but usually unpaid wages. You'd be surprised how many employees aren't getting paid. Like I've had claims where like an employee hasn't been paid in like 7 months. Yeah, it happens. So we get tons of claims for unpaid wages. We get tons of claims for termination pay. We get tons of reprisals as well. Overtime pay. Most of the standards, like every time I have a new claim, I open it up. It's fairly random, fairly different, but the top offenders, unpaid wages, vacation pay, termination pay, reprisals are usually the top ones we see. Any other additions? Yeah, and oh yeah, and then again, okay. So another thing, like I said, the major thing: keep all your evidence, all your hours of work records. If you don't have like a schedule, if your employer isn't taking proper note of your hours, you should. Because if you file the claim, we'll make our decision off the best available evidence. If you have all the evidence of your hours and they don't, we go with your hours. So if you have a very wishy-washy employer and they don't have records, they don't do things by the book, you yourself keep all your records. It will be very important for your claim.
There's no obligation for you to keep it, but we find that when we're doing our investigation, it helps so much. Because again, if you have an employer that's not paying you for 7 months, I mean, they're probably unscrupulous and they're gonna try everything they can to not pay you. So it's something I never thought of before I started this job, is keep my records. I don't have to, but it does help, even if you don't need it, but it's better to have it. So yeah, that is usually it. But again, the obligation is on the employer to provide us with records. But as Shay said, we do recommend you do that as well.
Sorry, I was just going to ask this question. First of all, this is a great session. Thank you guys for putting it on. And just to sort of piggyback on this young lady's question about employment, do you also offer internships for any of the roles for the officers in any of the programs?
Not that I'm aware of. I believe because the training is extensive, it is a little bit difficult for, internship purposes, but not that I'm aware of at this moment. So I wouldn't be able to say that there are internships.
I wanted to see if you could give us a bit more information
on work refusal or refusing unsafe work in the workplace, because I think that's an area where a lot of members, I say members because I'm a union member, a lot of employees may feel uncomfortable and feel that they have to do whatever the employer is saying just because it's coming from them. But there are occasions where, you may be able to refuse because it's unsafe. I know I did health and safety for a couple of years in one of my offices, and we've had to call the ministry at least twice. But can you maybe take us through that? Like, you call the ministry and you come in and you assess the situation to see whether or not it is unsafe work. Could that make sense? Then what's the next step? If you agree with the employee that is unsafe work, what's the next step for the ministry? Thank you.
Yeah.
We'll send that answer over here.
Yes, please. Thank you.
So when a construction inspector goes to the job site, obviously he's taking the complaint, and then he's going to investigate that particular complaint in terms of how it is going against what the legislation is saying that it needs to be. So then when they do that, they're going to write a field visit report, right? Outlining all their findings, pictures, all that kind of stuff, blah, blah, blah. And then from there, you have the right to get that information because it is public record. And so they're just going to, based on whatever the decision is, or whatever the decision, they're gonna, sometimes it's made right on the spot, and sometimes it needs a little bit of time where they have to now interview people and gather information, and especially if it's like a fatality or critical and stuff. So that's a lot of work. So I mentioned like the Downsview stage collapse that happened. That was 50, me working with my inspector, that's 50 binders of data collection, right? Going to court, because they also have to go to court too, right? So they have to make sure that they have all the information in order to now take that to court and stuff like that. So they do follow through with everything. You are more than welcome to ask questions. When the complaint comes in, it comes in to the contact center. From the contact center, it goes to the program assistant. The program assistant is then, there's a system, I don't know what the system's called, it's still ICE or whatever, but what they do is they create an event. And with the event, the person that you're speaking to is supposed to give you that event ID. With that event ID, you at any point can call back the ministry and then say, I would like an update, or I'd like to know what's going on, right? Now, if you want a whole, what the inspector did, in terms of like his full investigation, that at that point it now escalates to a freedom of information request. So that goes to the Freedom of Information Office. From there, it goes to the office that is managing that particular complaint. At that point, it goes to the manager, to the inspector, then the program assistant that's helping put that whole package together in terms of what you need. There's a cost involved in regards to that, depending on how much information you're looking for. For something like the stage collapse that happened, you want all 50 binders, they're going to charge you for all 50 binders in order to get that information. And then it takes some time for us to put that, or take some time to put that information together, right? So the inspector is there, is available. You're more than welcome to give him a call or whatever, but you are also entitled to get a copy of what the final investigation is, or the field visit report, right?
So I'm going to take one last question on the far side.
One last question on the far side. Oh, sorry, before you go. I did promise.
Yeah, thank you for the presentation. I do have two questions. One is related to the HR. So before reaching out to the Ministry of the Labor, how far is it important to reach out to the HR? This is my question, first question, because some of people I know, some of them, they advise not to reach out to the HR in case there is, let's say, for example, issue with bullying at workplace or any misbehavior, because HR is always working for the benefit of the company. This is as their priority, unlike the Ministry of Labor. And the second question will be about lawyers. Let's say employee has been terminated unjustly or has been subject to mistreatment, harassment, verbal abuse. So, or in that case, some of the employees who get laid off, they reach out or they hire a lawyer to represent them. So what will be the benefit of hiring a lawyer, or is it best of the interest to reach out to the Ministry of Labor at the first? Okay, thank you.
So as it relates to your first question, yes, you can reach out to your HR if you have an issue, and we would recommend that you do that. One, it creates a record of your complaint. And for example, if the HR does nothing, again, it helps. It creates that record to say, okay, I'm having this trouble, whether it's unpaid wages or whether it's harassment or anything like that. And I've reached out to the employer and they've done nothing. I've reached out to HR has done nothing, because that's what you're really supposed to do. And if in the case like that, the HR does nothing and you decide to resign, just say, then that helps with the constructive dismissal claim that you will have. Because an HR, while I agree with you 100%, they're paid by the employer, they're usually, try to do things for the employer, but at the same time, they're supposed to have an obligation to their employees as well. And any employer does have that obligation to their employee. So we do like to see if you follow the chain, but it's not necessary. You could file a claim right away, but we do recommend if you try to resolve it with HR, you should. But yes, it's good to have that record to say, yes, this has happened. I reached out to HR, they did nothing, and so I just left because it's just too toxic. And that helps to play into your claim for constructive dismissal. And do you want to add anything to that part before we get into the second? All right, and then as it relates to the lawyers, it will depend. You can always come to the ministry if you don't want to have illegal costs. But there are times when you don't understand your issue that you're going through, and a lawyer can help you to explain that, okay, this is what is happening, and then they can help you to articulate your claim to the ministry, because we do have claims that come through the ministry that they're represented by lawyers. So we do have those. So it's not all the time that the lawyer will take your claim on and work it on. They will recommend sometimes that, go through the ministry with this one. We could represent you at the ministry level. But when it comes to our powers as ESOs, if we don't want to, we don't have to deal with a lawyer. We can deal directly with you. But if you say, no, I want you to speak with my representative, we're okay with that as well. But we don't have to go through a lawyer if we don't want to when we're doing our investigation. So it is definitely entirely up to you whether you want to choose to seek legal advice. At the end of the day, the lawyer will definitely go through the ESA and tell you what may be going wrong with your employee or employer. And that's the same thing we will do. We go by the ESA as well. So if you want to just file a claim, that's fine. But if there's aspects that they may want to take to court, then it's definitely. And the reason why I say that is because there's some part where we go with minimum standards. So for example, if it's termination pay, the maximum we can award is 8 weeks. So you're working for a company for 20 years, the maximum we can award for termination pay, it's 8 weeks. Severance may come into play, and this is, a lot of people confuse termination pay with severance pay. Severance is different. Severance is about kind of loyalty to the company, so to speak. You've been there for, to be entitled to severance, you have to be employed for a minimum of 5 years, and the employer have to have a global payroll of $2.5 million. So if they do, and you're employed for 5 years or more, then you're entitled to severance. Now, severance we can award up to 26 weeks. If you've been employed for 26 years, we can award 26 weeks. But there are times when a lawyer will say, you know what, I don't think 8 weeks is enough. We could get more if we go legal. Then you could take it to the courts. So in cases like that, yes, you could go to a lawyer if a lawyer thinks that, you know what, the ESA is just going to try to do minimum, because again, that's what we established. Unless you have a contract with the greater right, as you mentioned, then we enforce the greater right. We are allowed to do that. So not because we always say it's the minimum, we enforce contracts that says you have a greater right or benefit. We enforce that. But again, it definitely is, goes to the legal system if the lawyer thinks they could get more than the minimum that we may offer. Good.
All right, thank you, gentlemen. We're going to take one last really quick question, just over here in the back, and then we're going to take a break, and we'll come back up to listen to our next speaker.
Hi, sorry. How does it work with employers that have a track record? So they're repeat offenders. Is there like some kind of progressive discipline on your end, or are the fines and penalties always fixed?
Yes, so there is. So it usually starts off with like the first fine, and then if we find that you're a frequent offender, the fines build off of that. So the first fine is about $250. Then it starts building off of that, and then it also depends on the number of employees as well. If it's like a really, really serious offender, then there could be a prosecution, which could be thousands of dollars as your fine. We also do we typically try to inspect repeat offenders. So we'll go to the employer at some point in the year, inspect their records, going back about like 2 years or up to the last inspection, just to make sure they're complying with the ESA, paying the minimum wage, paying vacation pay, or just all of that. So these are initiatives we have at the ministry to try to keep repeat offenders in check. Yeah, I don't know if that answers your question. The inspections.
Like, do you poll the employees to see if they're being compliant, or do you just collect records?
So we speak to a couple of employees, but we reach out to the employer, and they have to provide their records going back 2 years for all employees. So it'll be like all your pay records showing where you paid their public holiday pay or their vacation pay. It usually takes a lot of time, because like if it's a place where there's like 20 to 50 employees, you get 2 years of records for 50 employees, and you have to go through all of those, just pretty much ensuring that the employers are acting right. So this usually goes off your claim. So if you were to file a claim against me per se, it stays in the system. If we get 3 to 4 claims from the same employer, it will probably trigger an inspection. If I decide to work on your claim today and I find that this employer might not be paying other employees properly, I can start an investigation as well. And that investigation will get assigned to some officer or to myself, and then we'll go and investigate the employer.
Hello, I think. Okay. Sorry, I'm not really technical with the mic, but I would really like to say thank you to Carey and Shay from the Ministry of Labor, all that mouthful, training, development, and skills, immigration. I said it out of order, but I got all of them. Thank you so much for the time that you've taken today to help inform us and give us practical information that we could use and carry out in our jobs, whether that is in the construction field or outside of the construction field. A lot of what information came out from your presentation today is super useful. So thank you for enlightening us today. Thank you. And then our fabulous Tanisha.
I think they did an amazing job. we've learned a lot, right? We've learned a lot coming with all the questions. I think that you have learned something, and we're so appreciative of these two gentlemen for spending the day with us among so many women. I hope you weren't intimidated. All right. So we can officially call you allies because you're supporting us, right? All right. Can you just put your hands together for our allies? All right. So as a token of our appreciation, we want to present you with this little gift to say thank you for spending the day with us and sharing this information. Before you, we also heard an amazing presentation from Nadia. Give Nadia another round of applause because there's so many takeaway from the presentations that we've had, before. And I wanted to skip lunch and go straight into the next presentation, but I feel like everybody wants a break right now. Do you need a break? All right, good. Okay, so what I'm going to ask you to do, we have a wonderful lunch prepared for you downstairs. You can grab your lunch and come back. Our next presenter is here, ready and raring to go, and she has so much for you. All right, so we want you to grab the lunch, come back, and let's continue this session. All right, thank you.